In Anglo-Saxon England, slander was punished by cutting out the tongue. These days, when slander is published, we sue people for millions of dollars and we call it defamation. A recent string of cases has thrown Australian defamation law under the spotlight, and critics say our laws, which were last updated in 2006, are no longer relevant to modern online and digital publishing. In 2018, the New South Wales government volunteered to lead a national review of our defamation laws, and then in August, New South Wales passed reforms to change our defamation laws in line with recommendations from that review. So, what's going to change? And why is it such a big deal? Defamation is when someone publishes a false statement about another person and that statement damages the person's reputation. It's usually a civil suit when one person sues another person for money. And in rare cases, it can be a crime if the defamation is intentional and serious. There are a few ways to defend a claim to defamation, but one of the most common defences is truth.
You can't handle the truth!
If what you published was true, you won't be held liable. Of course, sometimes it can be difficult to prove if a statement was true. For example, if you're a journalist who doesn't want to reveal your source.
For a journalist in Australia to try and publish an article of public interest, there was often a lot that was required for a journalist to be able to get that article to print. So not only would they need a number of sources and sources of integrity, of reasonable belief in the truth of what they were publishing, but usually they would have to have sought a comment from the plaintiff, which sometimes could have resulted in plaintiffs threatening litigation or even seeking injunctions sometimes. And that can have a tendency to shut down that type of journalism.
Another reason to update our laws is that they haven't been refreshed since 2006. To put that in perspective, Twitter was created in 2006, Instagram didn't exist, and TikTok was a decade and a half away. Most news outlets had an online platform, but they looked a bit like this. Music sounded like this. Defamation back then was mostly TV, radio, and print newspaper publication. But today you can defame someone by a Facebook comment or by roasting someone on a Google review. In 2017, more than half of all defamation matters involved digital publications, which is a threefold increase in 10 years.
Part of the problem we have with defamation law is the plethora of cases. There are 10 times as many defamation cases per capita in Sydney as in London, and the majority of those are at the lower end of the scale. Typically, people getting upset about comments on Facebook that could probably better be resolved over a cup of coffee and don't really involve much in the way of damage to reputation or financial loss.
So what exactly has changed in New South Wales? The key aspects include a new cap on non-economic damages. That means harm that's not strictly financial, but could be pain, suffering, inconvenience, or loss of future income. A new public interest defence, a serious harm threshold so minor claims don't end up taking valuable court time and resources. A single publication rule, meaning that once something is published online, each new download does not create new publication. Concerns notices must be served with time and opportunity to make an offer of amends outside of court. And a new defence for peer-reviewed matters in academic or scientific journals. These might all seem a little bit specific and nitty-gritty, but the changes could have major impacts on how defamation operates in Australia. And the hope is that minor claims and disagreements can be resolved outside court.
And those sorts of disputes are generally better suited to a cup of coffee and a private resolution than spending tens or hundreds of thousands of dollars in litigation.